Brian DeLong, to my right, who will be moderating the program. And we have Mark Hall, who is Professor of Law and Public Health at the Law School, Katie Harriger, who is Professor of Politics, Earl Smith, Professor of Sociology, and Brian Shelley, Assistant Professor of Politics. So welcome you all. Thank you very much. I just wanted to underscore before we start that even though the debate team is sponsoring this, we didn't set this up as these people will not be necessarily debating each other. They're here to talk briefly on the subject and answer questions from the audience. And so after a brief statement from each of them, we'll turn it right over to questions and answers. So I hope you have some good questions ready. And if you've gotten one of these handouts, it gives you the different positions that are being argued this year by the nation's debate teams on this particular issue. So, Brian, why don't you start?
Okay, I'm just going to give a short introduction to the decision and some of the arguments that we think are important, or at least the debate team has found important as we go out into our tournaments. So the topic that we have this year is a little different from topics that we've had in the past. We are just focusing on the Supreme Court and overturning 4 different decisions, and one in particular is the 1974 Milliken decision, which is the focus of this topic. And so, you know, it's nice, it's different than focusing on things like Congress and legislators. And okay, so. The Milliken-Bradley decision, the Supreme Court used the distinction between de facto and de jure segregation in order to foreclose desegregation efforts across multi-districts. And the difference between de facto and de jure is de facto basically means it's not implemented in the law, and segregation just occurs because individuals potentially made the decision to segregate. So populations have the choice to segregate away from each other, and it was not implemented by the law. Whereas de jure segregation means that laws or decisions by local governments or state governments, federal governments, etc., implemented mandatory segregation of populations. And the difference in this is very important when it comes to the debate topic. People that affirm that this decision should be overruled, they say that if we allow for de facto segregation to continue, that multiple social issues, social and economic issues, cause the segregation of populations. It's not just the government itself, but a long history of impoverished people cannot get out of their current situation unless the government steps in and protects populations by causing segregation or desegregation. So people claim that this decision is the death knell of Brown versus Board of Education. The federal district court in Detroit held that, or said that 53 of the suburban schools within Detroit were supposed to be a part of a desegregation effort, and the Supreme Court said that that is false because the surrounding suburbs, the surrounding 53 suburbs, were not responsible for the segregation of populations. It's just where people live. The effect of this caused a lot of white flight. What that basically, means is if segregation occurs within a city and people with the monetary ability to leave a city to go into the suburbs, they take all of their money out into the suburbs and leave a lot of poor individuals behind. All right, now some of the arguments that we have brought up thus far is how can desegregation efforts be implemented? If we take away the distinction between de facto and de jure segregation, and the government says that segregation to populations is against the Equal Protection Clause of the 14th Amendment, then indefinite segregation will happen in the future. Does that mean that we go back to the 50s and the 60s and we start busing people? Or do we have more of choice ways to get rid of segregation? Examples of that could be magnet schools, vouchers, so whether or not we should implement those type of policies in order to get rid of segregation is kind of an important question that has been brought up thus far. The other question is a question of federalism. Should the federal government be able to get involved and dictate what local schools should do to decrease, segregation? Judges that have not been elected, should they be able to have the power to decide local school policies? Would they effectively be able to pass desegregation? It's a very good question because it could also undermine the ability of people to lobby their legislators or to be able to lobby courts that are, since there's only, 13 federal district courts. If you cannot be able to lobby these judges, then your power to get involved in governance is restrained. The other question that we have raised as well is court legitimacy. Should a radical decision of the court to overturn past precedents, if that occurs, what type of social backlash could happen? Will people no longer believe in the legitimacy of our court? And these are all problems that happen. Now, some other questions are, should race be used as a factor? Maybe socioeconomic situations should be a way that we should desegregate. And the final question that's also been raised is the legal system itself is slanted. A lot of white privileged litigators, judges, even legislators are predominantly white. And so even if we overturn the decision to get rid of desegregation, it still seems that